and she misapplied Section 204. What are your submissions on that score?
Section 204 is actually very clear, Justice. It doesn't say someone must admit anything.
Yes.
It clearly indicates that the state calls someone in the state case who may incriminate himself or herself.
Correct.
Yes. So if him or her doesn't do that, it doesn't mean he can't be indemnified. But the question is, how do you indemnify someone who doesn't concede to a crime that he's cautioned with he may incriminate himself with? Because if a court warns or reads Section 204 to a potential incriminating witness, it cautions him that you're going to be asked questions either by prosecution or defense which might incriminate you on fraud, in this case of charge 2 now.
Yes, but that's exactly the point, Mr.
Yes.
Mr. Edelin, because what the court then does is to refuse an indemnity, which is also a misapplication of Section 204, because Mr. Tlezula had a right to be heard. I mean, the cases make it quite clear. Now, if that is so, the case of the state is severed on the question of the letter, the 3 October letter,
Yes, the World Windows
and the
letter.
deviation memorandum,
Yes.
and how it came about that the deviation memorandum was drafted. So
Was
that is
made,
the
was
end
made, yeah.
of the state's case on those 3 points, and with it, and please I'd like to hear your submission on that, Mr. Edelin,
Okay.
with it, common purpose.
Yes, but remember the chart says amongst all of them, not only 1 or 2, all of them.
Yeah, but nonetheless, common purpose on that aspect is gone, isn't it?
Yes.
Yes.
Now, Justice, let's just have a look at what the court, I'll quote, did with the 204. It didn't give him indemnity, correct? But it's neither here or there, it's moot, whether he got or didn't, with regards to what he's trying to say against the third respondent. What is he actually saying? He's saying, she came to me and she dictated me the deviation.
No, but Mr. Edlin, with respect, and I don't want to debate this unnecessarily with you, isn't the point this, that because that evidence is taken out of the equation, that in turn influences the application of Section 174. Because in the judge's view, there is no evidence for this, for these, any of these on that aspect, put it to your client, for your client then to go into the witness box. There's not a prima facie case made out, because Mr. Tlezula is a lying and mendacious witness.
He discredited. He's
Yes.
discredited. Yes.
Now, does that not critically affect the decision to discharge? I can't see it any other way unless you
Let
can
me-
persuade me there's a different way
I'll try
of
to do
approaching
that.
the matter.
I'll try to do that.
Yes.
Let's accept the judge was wrong, I'll work, as you are putting to me. How would it differ in evaluating the discretion under 174? That he was a credible witness and one could accept whatever he said was correct with regards to the elements in charge 2. How could she convict number 3 at that point in time with Tlezula's evidence? If everything was accepted correctly, that's the submission I'm making. It's not a point of law. The discretion comes as a point of law later, of the facts. And if the facts are found wrongly by the judge, I quote, then it's wrong.
No,
Let's
but
say-
Mr. Edelin, Mr. Edelin, she got to that conclusion, that is the judge below, got to that conclusion by a misapplication of Section 204.
Yes.
That's how she got to that conclusion. So if
Yes.
there was a misapplication, what's left? Because as a result of that misapplication, the court concludes there is no prima facie evidence to put the respondents involved in charge 2 and the evidence that's covered by Mr. Tezula on that charge is now worthless, and they don't have to answer. And there's no prima facie case, ergo they are discharged.
I think, Justice, we should be careful when it comes to prima facie evidence. As previously, which could be detrimental if you don't come and testify. Negative inference can be drawn. I'm not there. That was the position. The position now is different. Boxers clear, Shuping, many of them, and Handley, Hotley, and all of them that follow in this court. Can Lady Justice in the court quote convict number 3 at that point in time, whether whatever mistakes on the facts were made, or 204, 174 plays a role now? She doesn't believe Tezula, but let's say she had to. What could she convict on? Prima facie is not the golden rule with the greatest of respect. It's whether the court at that point in time expected number 3 to either come to the witness stand or convict. That's my submission. And to do that, you say there's prima facie because you made a mistake, error in law 204, and could be so. But what did she convict in the end, 174, even with those mistakes? Let's say number 3 closed, like number 2 did, or number 2 did. Greatest of respect is nothing. Because to say, yes, the World Windows letter and the deviation, many of these documents are not before the court, which Mr. Kasim argued, many of them. Rightly or wrongly, she didn't allow those documents as not exhibits before the court. Must she not go into the witness stand and say, yes, incriminate herself? No. Yes, I did, or I didn't, or I did dictate, or I didn't, or I did see the window. Remember, there's one thing that bothers a lot. If you look at the record, somehow the World Windows IPEX Private Limited letter, 3rd of October, must have had other documents with it. New line, bank statements, bank numbers, all sorts of things that's not before the court. Nobody knows how it happened, it got paid. Because whether it's Logies or the BAS system for payment, you can't pay unless you have those details. Where did Tezula get those? Or how did Lamini, third respondent, get involved in that? Something's very wrong somewhere. That's why original documents and the chain of events of custody and all those things plays a huge role. To merely accept prima facie evidence, wrongfully adjudicated 204 and so forth, doesn't take the state's case further with regards to common purpose and to fraud. Fraud has got various elements, 5 or 6 of them.
But let me get this. I just want to understand your submission. Item number 3 is a CFO.
Yes.
And he played a key role in approving a procurement deviation based on an unverified letter from this World Window
Yes.
text. Now, why should the law excuse such a failure in due diligence without a full trial?
Without a?
A full trial. Why should he be discharged at 174 stage instead of running the full trial?
You see, Justice, it's a very good question. I appreciate that. The question is, what are the responsibilities of the CFO in terms of the PFMA or the SCM policy that they had at the time? She only recommended, didn't prove. She was informed this is a possession. Remember, there's a chain of events long before it gets to her, the CFO, who's the senior of the province. Many people do their job before it gets to her. And then she recommends. It's not her responsibility to finally approve. And therefore, how can one blame her for anything in that regard? And that it's a degree of blameworthiness. wrongfulness, all sorts of elements of fraud. It's not there. It's not proven. With greatest of respect, Justice.
But would you deny that the third respondent actions led to payment being made to Nulani despite Treasury regulations requiring proper procurement procedures?
No, because deviation is not necessary non-procurement procedures. Deviation is contained in the Act, it's contained in the SCM, it's contained in the Treasury regulations, as long as it complies with the prerequisites to deviate. And nothing of that's before the court.
Thanks.
That's the court. You don't need it.
If one applies section 174 of
Yes.
the Criminal Procedure Act, do you consider circumstantial evidence?
We have to.
You have to.
Yes.
Now here's the circumstantial evidence. You have a CFO who signs a deviation letter with only one letter, no contract. She's looking after the finances of this particular department. And she signs this deviation without any other documents. That is the evidence.
Can I answer that?
Yes.
Right. Circumstantial evidence. Locus classicus is the Blom decision.
Yes.
2 legs is the only reasonable inference that were the only documents before. That's in dispute. But that's not the factual finding.
No, Mr. Edmund, the evidence of Mr. Zula on this issue was clear. He received only that document when the deviation was signed by her. She is the one that took the deviation letter to the HOD. So, now the state alleges that there was a common purpose here to defraud the department, and her actions were part of the scheme to divert and circumvent the normal tender procedures in terms of 217 and the PFMA. Now, is there circumstantial evidence to come to that conclusion?
That's not the only reasonable inference.
What would the other one be?
That the deviation happened because there were lots of other documents which was put to Kezula. Where are the other documents? It's not only the deviation document or the Windows India letter that was there. How did they know about New Line? Where does that come from? It's not in the Windows letter. With other reasonable inferences.
Well, we know that the evidence is New Line must have registered on the central database.
It had to
Yes,
be paid under the BAS system because the Loki system wouldn't have paid.
precisely.
So it had to be under the
Is
BAS.
that really a question at the circumstantial evidence stage, whether how they paid or not paid? What we do know is they registered and they were paid because they were a registered service provider, and that registration happens at a centralized place with Treasury and not with the department.
Yes, provincial treasury.
Precisely.
Yes. Now the point is, those documents might have contained other documents. Is another reasonable inference, which included New Line.
But it's not about the documents. It is about her signing the deviation, her recommending to the HOD,
Yes.
her putting it on, giving him the instruction, her taking the document to the HOD.
Yes.
Yes.
Yes. Now let me.
And can Lena say, based on that evidence, the only reasonable inference is not that she knew what is happening here.
No, that's speculation.
Any other one would be absurd.
No, we can't speculate, my lord. Let's look at the objective facts in the record. Objective facts are: she was approached by Kezula. He's got another version. But let's work on his version. That she went to him and said, "There's a Windows letter, you must dictate the deviation, there's a deviation here." For whatever the reasons are, which is not clear. Kezula doesn't say what the reasons were. And now she dictates to him, let's accept what he says, how a deviation looks, because a deviation must contain certain allegations, as within the PFMA or the SCM policy or the provincial treasury or the regulations, and actually the regulations, the SCM regulations dictate.
Mr. Edelin, can I cut through all
Sorry,
of this
mate.
by
Sorry,
simply
Justice.
asking you this? She signed the deviation memorandum, the third respondent, did she not?
I'm sorry, besides the what?
She signed the deviation memorandum. Yes?
Yes, she signed it, yes.
Yes.
It's not in dispute because
Yes,
we didn't
yes,
dispute
no.
that in the hearing.
Now, when one looks at the deviation memorandum, it contains the exceptions for when you may deviate from the SCM policy.
Yes.
Not so.
Yes.
Yes. So when you look at the reason that's given, i.e., that Nulani must be appointed, in essence, that's the reason.
Yes.
There's no compliance with the regulations made under the PFMA. So the short point is, could she have seriously approved the contract in these circumstances?
I think so, Justice. I'll tell you why. Because the Windows letter said there's R1 billion and they're only prepared to work with a certain company who works worldwide. This is New Line apparently. And otherwise, if they're not going to put money in World Windows wherever they work, if they don't work with New Line. And that's an exception where you deviate.
So in short, I don't want to debate
That's
this
what
point
I'm
any
saying.
longer with you. You saying that she was completely justified in accepting what was stated in that memorandum. It's a simple yes or no question.
Justice,
Answer.
she was bona fide in recommending or signing.
Yes.
That's what I'm saying.
Thank you.
Just a very short question. The trial court found that the third respondent did not act in common purpose with others in the scheme. But is it not a legal issue whether common purpose can be inferred from conduct rather than direct agreement?
Yes, it can. There's many case law on that. Conduct, it doesn't have to be colluding where you have evidence to that specific. It can be silent also. Yes.
So you agree that the trial court did not correctly apply the common purpose doctrine?
If one finds that there was devious purposes, that's the end.
Thanks.
But that's not the facts the judge did.
Yes, thank
or
you,
wrong.
Mr. Edling.
That's
Is
a
there-
factual finding.
Mr. Edling, are there any further
I'm
submissions?
indebted to you.
No, I'm asking
I'm
you.
done. I
You're
think
done.
I've made my point.
All right. Thank you, Mr. Edling.
Thank you, Mr. Judge.
Mr. Forbeck.
Justices, afternoon. Justices, likewise, I'm not going to echo what my predecessors have already placed before this honorable court, and I do not wish to rehash our heads of argument as well. Same is before this honorable court. But I would like to start off, Justices, and add on to what Mr. Nell has submitted. And if one has due regard to the state's application and the submissions made by Advocate Castle, the initial part of the state's application, it is clear that he was arguing the facts. Now, Justices, with respect, we are not here to rehash the facts that was found by the trial court. We are here simply to evaluate and come to a finding whether or not the trial court erred on questions of law. Now, the state has conceded that on the 8th and 9th points, there is a problem. And with respect, we concur with it. And that is our submission further to that. Now, Justices, with respect, the Schoeman decision and the requirements for a 319 exercise is crystal. And we would submit with respect, bearing in mind what preceded the 319 application was the 316 application, which correctly my learned colleague pointed out. The 319 application mirrored the 316 application. And it is quite evident that the state is trying to disguise the application as a 319. Now, justices, with respect, the requirements are clear in all 9 points. It must be clear what these points are that the state wants to reserve. And it must be framed in such a manner that it is quite evident. Now, on all the grounds, with respect, the state's application suffers fundamental defects, that it is not questions of law, but in fact, factual findings. And I echo the sentiments of Advocate Eerdler, that whether or not the trial court erred in some regards to factual findings, it's not for this court to rehash that finding or to revisit that finding. Now, what the state's case is based on is a deviation. Respondents, the 4th and 5th respondents, are not party to that deviation application. But however, justices, with respect, and the argument centers around Sezula's evidence. Now, if one accepts the version that, or his version rather, that there was only one letter, the World Windows letter. With respect as well, justices, there's no evidence before the court to quote that that letter is not what it purports to be. And Umtolo was questioned on this aspect, whether or not he furthered his investigation to a point where he engaged the company in England. And it is simple, he did not. And it is obvious that his investigation was goal-driven. He wanted to achieve a specific point. Now, Sezula's evidence with respect to justices cannot just be viewed on that aspect alone. Because if one has due regard to Mahlangu's evidence, it is quite evident that there had to be other documents. So, the inference that is supposedly to be drawn, and the state is arguing that point, is that this deviation, it is obvious that this deviation only relies on the World Windows letter, which is factually not correct if one has due regard to what the other witnesses testified, and specifically Mahlangu in that case. There must have been other documentation. There could not have been payments effected if those documents were not available.
Is it then coincidental, in your submission, Mr. Forbey, that the World's Window reason, i.e. that Nulani must be appointed, finds its way into the deviation memorandum? Is that coincidental?
Justice Skippers, with respect, the letter is silent on that. The World Windows Impact Letter does not specifically state Nulani must be appointed. So that is exactly the predicament that the states find themselves in. And one must not lose sight of the burden of proof The burden of proof throughout rests with the state.
But then I'm missing something, Mr. Forbay. I mean, at the end of the day, Nulani received the money, did it not?
Justice, yes, that
Nulani
is
at no
indeed correct.
point, Nulani at no point suggested, well, we cannot be paid because we're not the persons that had the contract, or we're not the persons that were referred to. We were not the entity that was referred to in the deviation memorandum. I mean, really, you see, it seems to be that, is this not a case where the steps that brought about the existence of the contractual relationship and how that relationship came about was proved by oral evidence? Unless I'm missing something.
Justice, that's exactly the point that I'm making. The state had to prefer that evidence. And there's a lacuna. There's a vacuum in the state's case. It is quite evident, and one cannot argue otherwise, that the money was paid from the department and it ended up in Ulan's account.
Yes.
That is a fact. Hence the submission.
So Nulani, could it have been anybody else that was contemplated in the deviation memorandum?
The point that I'm trying to make, Justice Skeppers, is that there must have been other documents from Ulan entirely for that deviation. So Zula's evidence on that score fell short of convincing the court of the truthfulness and the reliability and accuracy of his evidence. And with respect, my learned colleague's argument on credibility findings in a 174 application is misplaced. A court can, in circumstances where the evidence is of such a poor quality, take credibility of the witness into cognizance, even in a 174 application.
Are you saying the evidence in this case is of such a poor quality that the court...
Mr. Zula's evidence, with respect, Justice, on that, and why I'm saying that and why I'm starting, that's my starting point, because that gives rise to the count, the second count of fraud. Count of fraud.